Let me start with a little housekeeping items here while others are signing in. We have a chat function that's, I understand, in a balloon that's on the lower right-hand corner of your screen. And if you have a question during the presentation, you can just type it in there, and we'll try to answer during the webinar or for certain at the end of the webinar. Now, as far as the slides are concerned, we're going to be distributing those by email to everyone who's registered and gave us a valid email address. Now, the title may not be the clearest, and it talks about using the Amgen-Sanofi methodology to identify the historic treatment of patent eligibility issues. And what that means is Justice Gorsuch in the Sanofi case did a historical review of the enablement cases that had come up before the Supreme Court of the United States, which began about 1813. Today we're going to do approximately the same thing, but what we're going to be looking at is primarily the abstract ideas. Now, one thing that's important to understand is the United States is, as you all know, is a common law country, which is a historic accident of us having been a colony of the United Kingdom. And the United Kingdom was a common law country. Now, it's important to understand that by being a common law country, that means that our laws generally, especially at the time of the early 19th century, were not necessarily developed by Congress, but were actually came from court decisions. England became a significant trading country because of their common law tradition, which resulted in them having a very robust contract law, which was consistent and applied consistently by the courts in England. And that didn't happen overnight. England started on that path back in about the 11th or 12th century with Henry II. So let's see, it's 9 o'clock, so your time. So we should start. First, let me introduce us. I'm Dick Kelly. I'm a senior partner with Oblon. With me is Lucas Koziol. He is an associate with Oblon. Now, our email addresses are right there on the first slide, so if you want to send us an email, you don't feel comfortable using the chat box, feel free to do that, and we'll answer them probably after the show. Now, let's slides are being. Now, the key here is, as I mentioned, we're a common law country. And if you don't understand the history of statute, you're going to be lost, because American statutes especially are pretty bare bones. The expectation is that the courts will fill in any of the gaps that may be there. And so you have to understand the history to understand what's going on. In patent law, now some of the laws start with Congress, but those are primarily the newer ones, like the antitrust laws and the AIA, for example. But here, even the AIA, you have to understand the case law, because you may not, if the case is the law, is not necessarily interpreted the way it's written. And there's a statement by a few British people over the years that those who don't know their history are doomed to repeat it. And I'll tell you, in patent law, that's definitely true. Now, the courts we have three, our government is tripartite. It has a executive branch, a legislative branch, and a judicial branch. And the judicial branch is number one in explaining what the law is. Now, did not get that position because of our Constitution or an act of Congress. They did it by actually asserting it in 1803 in a case of Marbury v. Madison, and every U.S. attorney learns that early on in constitutional law. Now, what we have in patent law, the common law begins with the English patent system. Now, the English patent system prior to 1624 was strictly at the discretion of the crown, the king or queen as the case may be, with the help of the Privy Council. And the English kings were giving out patents long before there was actually any statutory basis for it. Initially, the kings were using it to try and attract technology from Europe. England was the backwater of Europe in terms of technology, and basically they were the China of their day in trying to basically steal the technology by inducing people to come to England with the inducement of getting a patent and making a lot of money through the monopoly. Now, this changed with the statute of monopolies that was passed in the early 17th century. I've read different dates. We'll use 1624, that's the most recent one. Now, the statute of monopolies dealt with not just patents, but a number of practices that Parliament didn't like about what the king was doing. But with respect to patents, the statute of monopolies is very simple. The section's very short. The Parliament said that to issue a patent, the manufacturer, and it was limited to manufacturers, must be new in the realm. They could be new on the continent, but if they weren't in the realm, you could come over to England and get a patent. They had to be for manufacturers. We didn't get them from anything else. So process patents didn't get issued in England until the mid-18th century, when English courts decided that that was a little bit too restrictive. Again, Parliament didn't have anything to say about it. The court did. And finally, the last thing, and the only other requirement, was that the patent could last no more than 14 years. And what happened from there is that the English courts had to decide what was required for a patent and what was permitted to be patented and not patented. Now, this is not unique to England. The United States does the same thing today. And if you remember the case of Jacobarty, it decided microorganisms were patentable even though they were alive, and even though the attempt to patent plants, which were also alive, failed until Congress passed a specific statute providing for it. And at Chakrabarty, they didn't have to wait for Congress. You're very old waiting for Congress. They did it by court decision. And you'll notice that the plaintiff in that case was Diamond. Diamond was the commissioner of patents at the time. And the United States Patent Office was trying to avoid having to allow patents on microorganisms. And the Supreme Court didn't think that was a bright idea. Now, what we have is there was no specifications, as I said at the beginning with England. And what happened was the English, over the period of the 18th century, came up with the concept of a specification, and this requirement was right there on the slide. Basically, it had to be sufficient so that when the patent was over, the public could get the benefit of it. This is not that dissimilar from the U.S. cases that are cited by Justice Gorsuch. Now, this was a 1778 case decided by a Lord Mansfield, and it was Liardet v. Johnson. And this is the first published decision talking about specifications that I found, or I found in the history that I read about specifications, but it was not to be the last. A few years later, in 1785, a Justice Buller, a Lord Buller, in the King versus Arkwright, basically had no doubt that in 1785, the function of the specification was to teach the public about how they can use the invention, and that this was not a new principle of law, but was already well-settled law. Interesting statement. He doesn't cite any support for it, and there's a lot of questions as to whether there was, other than the Liardet case. Now, it did make it immediately into the legal textbooks because Justice Buller wrote a textbook on it. And that's where the whole concept of specification came up, and the concepts of written description, enablement, all began. Lucas?
In Amgen v. Sanofi, the Supreme Court really focused on the policy behind the enablement statute by looking back at court decisions spanning over 200 years. The Federal Circuit in Amgen had not considered the policy of enablement. We'll discuss some of these cases in this talk.
Yeah, just an aside here. In Amgen, like in a number of other cases, the Supreme Court granted certiorari, not necessarily because it disagreed with the Federal Circuit's decision, but it was concerned with the fact that the Federal Circuit had not properly looked at all the issues that arise. Now, in some cases, like the Bachman decision, it was the right to a jury trial. Same thing with the IPR decisions.
Writing for a unanimous court, Justice Gorsuch considered 14 cases between 1813 to 2014. Two of these cases were narrowly focused on exactly how much routine experimentation that a patent can require to still be considered enabled. But most of these cases focused on patents where there was no enablement or very little enablement. A common theme running through all of this case law is the concept that functional claim language, without providing the specific structure that achieves that function, is not patentable as being abstract. In this way, enablement and what we now think of as patent eligibility under Section 101 have always been closely related in the U.S. patent law history.
Now, just an little aside here, a number of the cases that Justice Gorsuch cited, if you were to read the decision carefully, do not cite the Supreme Court decisions, they cite the Circuit Court decisions. In the 19th century, the American court system was different from what it is today. The district court judge had limited jurisdiction. He could hear cases, he could hear a number of criminal cases, provided the penalty was less than 30 lashes, sounds exciting, and it did not involve treason. And while for diversity cases, you had to have a certain amount of controversy to get in the federal court, if the amount was too high, you went to circuit court. Now, the circuit court's important because all of the circuit court judges came from the Supreme Court. That is, they sat on the Supreme Court at the time. And so they had a gentleman's agreement that once the law had been decided by a circuit court, all the other circuit courts, which means all the other justices, would follow that decision until the Supreme Court, or unless the Supreme Court modified or reversed it. It was the ultimate in stare decisis that things been decided. We wish that the Federal Circuit would express a similar view today. Now, when we talk about functional or abstract claims, the way the courts have looked at this over the years And the courts, I'm talking about the Supreme Court, and before there was a federal circuit, the district courts, they looked at them as being a concept of patenting an effect only without a description of the apparatus or operation providing the effect. And they said that's not patentable. It's not patent eligible. It's different than enablement in the sense that an enablement situation is the scope of the enablement which is challenged. In other words, the claim is broader than the enabling disclosure. With abstract claims, under our rules, you don't get a trial because there's no facts in dispute. It's strictly a legal question. Now, if you read this, you don't see the Alice Step 2 approach being done. But the reality is it's there. You first look at the patent claims and see if they're seeking the patent and effect only, and they don't provide the apparatus or means to achieve it, which are the two steps in Alice. Now, Whitmore v. Cutter is the earliest case cited by Justice Gorsuch. And in this case, it went on, it dealt with an abstract idea, and they decided that it could not be patented because there was no mode or new application of machinery described to produce these effects. Now, Whitmore v. Cutler is a federal case. That means it was decided by the circuit court. It was decided by Justice Story. Now, that's important because Justice Story was one of the longest-serving justices on the Supreme Court and wrote many patent cases in his career, decided many patent cases, both as a circuit court judge and as a Supreme Court justice. And in fact, he was the youngest and still remains the youngest justice to ever be appointed to the Supreme Court and was the longest-serving one. Now, what was expressed by Judge Justice Story was a concern for preemption if claims are to function only. That is, if you only have a functional claim, and that was to be allowed to stand, it would give you dominion over the whole field. We would only invent a single part of it. And this is explained by Justice Story. Again, in a federal case, this is some 20-odd years, 27 years later, in Wyeth v. Stone.
In Wyeth v. Stone, the patent at issue was directed to methods of cutting ice into uniform blocks by means of, quote, an apparatus worked by any other power than human, end quote. The court held that the concept of cutting ice using any apparatus was a, quote, principle in the abstract, since it did not recite any specific apparatus or specific method to accomplish this function of cutting the ice, and so it necessarily encompasses much more than it enables. In Stone v. Sprague, another 1840 decision, the patent at issue was directed to an improvement in looms, which are a type of sewing machine. The inventors had come up with a way of connecting two parts of the machine, the reed and the yard beam, such that when one of the parts was moved by the user, the other part also moved in a coordinated fashion. But instead of only claiming their specific system, the inventors tried to capture the whole concept of connecting a reed with a yard beam in order to communicate motion between them. The court found that connecting two parts of a machine was an abstract principle that couldn't be patented. The court emphasized that such a connection could be performed in any number of different ways, beyond the single specific way the inventors had actually achieved.
Just as an aside here, Stone was another case decided by Justice Story. And again, showing his activity. The other important point here is, although the case was decided in 1840, The patent issued in 1829 before there were claims. There were only embodiments. And the rule was if any embodiment was not patentable or not patent eligible, the whole patent fell. And so Mr. Stone lost the whole enchilada. Now we've all heard, maybe some of us have read, that the Constitution provided for patents to further the progress of the useful arts. Now many commentators believe that this is a broad, sweeping approval of many types of claims, including many people wrote that they approved the Amgen claims. However, the Supreme Court disagrees. In Leroy v. Tatum, 1852, the Supreme Court looked at this and said, by creating a monopoly like this, where there's only a result or an effect and not any means for achieving it, this would discourage the arts and manufacturers against the avowed policy of the patent laws. In other words, to further the progress of the useful arts is a restriction on patentable subject matter.
Leroy v. Tatum was decided way back in 1852, but it has been cited in 22 Federal Circuit cases just since 2007. The most recent time was this past September in a case involving GoPro. This shows that the ideas expressed in these early cases are still actively being used today to help decide important issues of patent law. Another case figuring prominently in Amgen was the 1854 decision O'Reilly v. Morse. In his patent, Samuel Morse claimed the use of electromagnetism for printing at a distance. This claim used functional language without requiring any structure of how to accomplish such use. What Morse had actually invented was the first telegraph machine, which we show a picture of here from his original patent.
Now, to put this another way, the fax machine, which was not developed until 1930s, would have infringed this claim.
In invalidating Morse's claim, the Supreme Court set forth two main arguments based on public policy for why they did so. First, the court thought that it would likely lead to a chilling effect in the new technology area of long-distance communications, thus preempting future research in the field. It hypothesized that future inventors might come up with technologies that also use electromagnetism, which could be totally different than and probably better than Morse's specific first-of-a-kind example of such a machine. But these inventors would have no incentive for doing so, since their discoveries would be automatically covered by the functional language in Morse's claim. Thus, allowing such a claim could stifle innovation.
Now, one thing I will say about the decision, if you ever read it, it sounds like it's an abstract idea decision until you get to the very end when they pin it as a enablement case. And it's an enablement case because they did have an example of how it worked that one could reproduce when the patent expired.
Second, the second policy reason was that the Supreme Court also emphasized that it would be unfair for inventors to benefit from an exclusive right to future inventions that they didn't specifically disclose and teach the public how to use at the time they filed the patent application. Thus, the public would not be getting the full benefit of the bargain of the patent contract. Similarly to Leroy v. Tatum, the Morse case continues to be cited in many frequent modern patent law decisions. Here we see that in addition to Amgen, which deals with enablement, Morse has also been cited in several recent landmark cases on patent-eligible subject matter under Section 101 as well.
The next is an 1895 case by the Supreme Court, which involved the Edison electric light bulb. Now, prior to Edison, a patentee had come along and gotten a patent on a light bulb that had basically a filament which was described as being a loop consisting of carbon made from fibrous or textile materials. The problem was the patentee enabled carbonized paper only. Now again, the Supreme Court came back to the concept that what they were doing was preempting the field, and that the patent would operate to discourage rather than promote invention. And this preemption and discouragement is a concept that runs throughout a lot of the cases involving both enablement and abstract ideas at the Supreme Court. Now, the patent did disclose an embodiment which used carbonized paper, but it wasn't exactly a great embodiment. The light died pretty quickly. Now, the Supreme Court did hold out that there might be a way for a patentee to obtain broad claims if he could describe some quality, general quality, that ran through the whole fibrous and textile kingdom, which would allow one to select such fibers without having to go through an extensive experimentation. And that might justify a broad patent. However, no such general concept was to be found in the incandescent lamp patent.
Turning back to Amgen, we see that Justice Gorsuch closely followed the logic of both Morse and incandescent lamp. Amgen's claims at issue tried to claim antibodies that were defined by their function only. The antibodies had to bind to specific amino acids on a naturally occurring protein and prevent that protein from doing its job of regulating LDL cholesterol. Gorsuch found that, similar to the patent owners who tried to claim all fibrous plant materials for the function of incandescence, Amgen was trying to do the same thing here for all antibodies that bind to and block this particular natural enzyme. Allowing Amgen's claims would serve to chill the technology area of antibody research and potentially prevent future new antibodies from being discovered. It would also give Amgen legal ownership over potentially thousands of antibody structures that had not yet been discovered. Also closely following incandescent lamp, Gorsuch noted that had Amgen identified some quality common that was present in each and every antibody that they were trying to claim, this may have been enough to enable even very broad claims such as these. Since it's well known that a specification doesn't have to describe and synthesize every single member of a claimed class. Gorsuch thought that by identifying such a quality, other future scientists would clearly know which antibodies would be covered by Amgen's patent and which would not, which would allow their research to avoid being caught up by Amgen's patent. Now, Gorsuch doesn't hypothesize in this case about what such a quality common could be for Amgen. However, in Amgen's earlier patents, which were not at issue here and were allowed, Amgen had claimed a set of 26 antibodies by specific amino acid sequences in a part of the antibody called the complementarity determining region, or CDR, which is the important part of the antibody that binds to the PCSK9 protein. So we can guess that somewhere between the purely functional language that Amgen used here and a full description of the CDRs by their amino acid sequences, there's a vast gray area that might have allowed Amgen to get something more in terms of the IP protection than they got with these functional claims, which was nothing. Covering this gray area effectively, such as by using a variety of narrow and broad claims, is part of the difficulty and the art of good claim construction in patent law.
Now, one of the things that in the Amgen decision, which hinted right away how it was going to come out, was Justice Gorsuch quoted from Amgen's expert, who said that if somebody figured out how to predict how a protein was going to fold, he'd get a Nobel Prize. And of course, one of the things that's important for antibodies is the folding. If they don't fold correctly, they're not going to work. And there were some other things, such as the ability not simply to bind to the site, but to also block it that were necessary, that were also not predictable. Now, we've all heard this thing about judicial exceptions. Well, according to the early cases, beginning at least 1813, scientific principles, ideas, natural laws were not manufactures. Remember, that's what the statute of monopolies was directed to. That is technology. That's how the term was interpreted by the American courts. Or to put it another way, it was not part of the useful arts. So today, many people are trying to tell the Supreme Court, don't create any more exceptions. Well, the reality is the whole concept of judicial exceptions didn't exist in American law until the Deere case, when for reasons which aren't clear, that term exception showed up in the text of the case. So the next one. Basically, if you look at the cases, there really isn't a clear line of demarcation in the mind of the court between patent eligibility, in other words, abstract idea, and enablement. Now, it shouldn't be too surprising since most of these cases predate the 1952 Act. Until the 1952 Act, patent eligibility, 101, enablement, written description, best mode were all part of the same statute in a long run-on paragraph. Congress hadn't really distinguished between them. Now, in 1952, that particular statute was broken up into 101 and 112, and 112 broken up into several paragraphs. Now, if you look at the legislative history, which you have to look at to try and determine what Congress meant, there's nothing in the legislative history explaining why Congress did it. But there is an article by P.J. Federico, who was the patent office guru who carried the water for the patent office of the 52 Act, who wrote a history and stated there was no intention to change the existing law, but simply to organize the statute. So the old cases, which kind of waffle back and forth, are just as valid today as they were back in the early 20th and throughout the 19th century. All right. There we go. The takeaway should be for you, but really, to decide whether a claim's to an abstract idea or not, you have to look at the claim and say, is there a means described for practicing the functional language? Now, you have to also do a claim construction to make sure that the claim terms that are used, in fact, would be interpreted to be such a means. But if there is no means described, which would allow one to make the device or to practice the invention, then it's an abstract idea. Now, this is important because if it's an abstract idea, you don't get a jury trial. You don't get any trial. Trials are to decide factual disputes. Question of whether or not a claim is to an abstract idea or not is a legal question, which is reserved solely to the court, and the jury doesn't get involved. And experts don't get involved, and there's no testimony. Now, if we look past today, one of the big items that's on the table is how are we going to handle artificial intelligence? There's a lot of issues on it. But if you go look at the early cases we've looked at, it's pretty clear that should be patent eligible if it's claimed properly. In other words, using artificial intelligence to navigate a car on a street, that would be a patentable invention. Simply trying to claim the algorithm, probably not. Now, the problem with AI is, how do I describe it once your program's been trained, and sometimes they're trained on hundreds of thousands of pieces of information, and certainly if you're training a autopilot, you're trying to make sure that it doesn't do what Tesla's autopilot did and drive into emergency vehicles. By the time you're finished, you're likely to not know exactly what that program looks like with the different weights that have been assigned to it by the AI. And so one of the things that you can do is you can look at how is this problem of written description and enablement handled with other inventions? Well, microorganisms, which really weren't describable. You describe it as a microorganism found on the north slope of Mount Fuji, and you might be using that to to grow an antibiotic, which is in fact where some of the antibiotics came from. How are you going to describe that to comply with the 112 requirements? How are you going to do it to comply with 101? Well, the problem was not addressed by Congress. It was addressed by basically the courts and by inventors, where they would deposit their microorganisms, where after the patent had issued, and certainly after it had expired, the microorganisms became available to the public to use. And one of the things we should think about for AI is we probably could do the same thing. Why not? Again, the critical thing for AI is going to be claim drafting. Because quite often, if you're talking about abstract ideas, many times it's how you draft the claims. If you look at the NEPCO case, which was American Axle, there, some claims were abstract ideas and knocked out, but others, Federal Circuit reversed because a proper claim construction showed that they did have a means of achieving the function. Now, Lucas and I want to thank you all for attending. If you have any questions that you'd like answered now, we'd be happy to do it. Again, you can use the chat function. And if you come up with some thoughts after, perhaps before you go home today, you could send us emails, and we're more than happy to try to answer them for you. So I want to say thank you. And for you, have a good day and enjoy. And take care.
Thank you very much from Tokyo.
Thank you.
Have a good day in Tokyo.